All right, so we're on the record in docket 25-00373. That is people of the state of Michigan versus Ryan Doherty. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Akanicki.
Good morning, Your Honor. Robert Akanicki, attorney for Ryan Doherty. He's present. Stand to my right.
Sir, you are Ryan Lester Doherty, is that correct?
Yes, sir.
Thank you. This is time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a jury trial.
Is that a fair statement, Mr. Akanicki?
Yes, Your Honor.
All right. So we'll set for jury trial on
May 13th.
May 13th at 8 o'clock. All right, so we've set for jury trial after the final pretrial for May 13th at 8 o'clock. You'll receive notice from my court officer. Anything else for the record in 25? I'll need a briefs a week before, as you know, concerning witness lists and jury trial instructions. Anything else for the record in 25-00373, Mrs. L?
Not for the people.
Mr. Akanicki.
No, Your Honor.
All right, thank you. We're all set. Thank you for your appearance today. And Mrs. L, there's a bunch of people on Zoom. Under the moniker of Paris, would you please identify yourself? Paris? What's your name, ma'am?
It is my legal name is David Lamb.
David Lynn?
Yes.
All right. And are you represented by counsel today, Mr. Lynn?
I think that I am.
All right. Is that one of Mr. Lee is out with the public defender's office?
David Lynn, yes, that again is
Mr. Harris. All right. You're in the right place. You're in the right place. Stand by, and then we'll call your case in just a second, or I might place you in a breakout room with your public defender. All right.
Okay.
Thank you. On the Motorola Moto G5G, would you please identify yourself? On the Motorola cell phone, I just let you in. You just
Derek
unmuted?
Lampman? Yes,
Derek
Lampman.
Lampman. All right.
And he's my client.
All right. Your public defender is here. I may put you in a room with him. You're in the right place. Stand by, all right?
All right, thank you.
You're welcome. All right, Mr. Hughes, let's call your case and then we'll call public defenders or call the other cases. So we're on the record, and Mrs. L, you ready on Mr. Hughes?
I am.
All right.
Hello.
We're on the record in docket 25-00777. That is people of the state of Michigan versus Glenn Hughes. Will the parties please introduce themselves to the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Glenn Elliott Hughes.
And sir, you are Glenn Elliott Hughes, is that correct?
Yes.
All right, you can hear me all right, Mr. Hughes?
Yes.
All right, thank you. This is a time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
And that's a fair statement, Mr. Lee.
Yes, it is, Your Honor.
So we'll set for final pretrial on,
April 22nd at 8:30.
it'll be set for April 22nd at 8:30 for final pretrial. All right, so Mr. Hughes, you'll get notice sent to your last known address with the court, which is the Tisdale address. Is that still a good address for you, sir?
Yes.
All right. And we've set it for April 22nd at 8:30. Anything else for the
Yes.
record in 25-00777, Ms. Azell?
Not for the people.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Hughes, you're all set. Thank you for your appearance today.
Thank you.
Mr. Harris. Case did you want to call first while we get?
Hello.
We can just go in order, Your Honor, with Lex, Smith in Washington.
Okay. So did you want, Lampman or Smith?
We can go with the Austin Lex, Your Honor.
Let's.
Excuse me, Your Honor.
Mr. Copeland?
Yes. My apologies. I was wondering, is there a way, I know I'm supposed to appear in person. I was wondering, is there a way I can appear through Zoom?
You're set for final pretrial today at 9:30.
Correct.
Most final pretrials are set in person.
Okay.
But since you're here, why don't you stay here, Mr. Copeland, and we'll go from here, all right?
Okay. All right. Thank you.
All right. So just stand by. All right, Mr. Letts, you can come up here. All right, so we're on the record in 25-00219. That is people of the state of Michigan versus Austin Letts. Will the parties please introduce themselves for the record? Mrs. Up.
Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lex.
And sir, you are Austin Allen Letts, is that correct? All right, thank you. This is the time set for a final pretrial today. Mrs. L, how are we proceeding?
Your Honor, at this time, the people are asking for an adjournment. We had an issue with our subpoena system again this week. I called the victim on this. Well, I apologize. The victim is a minor, so I did call their guardian on the case. And I talked to their parent, and their parent is a third shift employee who was unable to make it in this morning due to not getting that subpoena in time. Based on this, we have conveyed this to the defense. They were unwilling to agree to an adjournment, which is understandable. However, we would ask for an adjournment for another final pretrial.
All right, Mr. Harris.
Yes, Your Honor, that is correct. I spoke with my client about the prosecution's witness being unavailable and the request to have it set for a final pretrial. He indicated that he wished to still move forwards with the dismissal today. I indicated to him as well that if the case was dismissed, it would likely be refiled possibly even later today. And he indicated he would still prefer to have the case to move for the dismissal today.
All right, so my history of the case is it was set for final pretrial on the first pretrial for March 18th. It was set for today for April 1st, 2025. The people are requesting an adjournment of the pretrial for witness. Seems like you subpoenaed the witness and talked to the witness, but the witness isn't here. I will grant the adjournment. And we'll reschedule this. Mr. Letts is out on bond, so he's not incarcerated. And currently Mr. Letts is on probation to Judge Aquilina. Is that correct?
That's correct, Your Honor.
Okay. All right. So we'll grant the adjournment. We'll reset this final pretrial for
April 22nd at 8:30.
April 2nd at 8:30. All right, so this has been reset for April 22nd, 8:30. You'll receive notice from my court officer, Mr. Letts. Anything else for the record in 25-00219? This is out.
Not for the people.
Mr. Harris.
Now, from the fence,
All right, Mr. Letts, you're all set. We'll see you on April 22nd. Is it Smith? Jermaine Smith?
we have Mr. Smith over Zoom, and then we have Mr. Cooper here in person. I'm ready on both. Your Honor.
All right. Let's go on Mr. Cooper. And then we'll call Mr. Smith. All right, so we're on the record in docket 24-01070. That is people of the state of Michigan versus Shamar Cooper. Will the parties please introduce themselves to the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Cooper, who is standing to my right, Your Honor.
And sir, you are Shamar Cooper, is that correct?
Indeed.
Thank you. This is the time set for a final pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people are extending a plea offer to the defendant. The plea is to an added count 2 of embezzlement under $200 under MCL 750.1742, which is a 93-day misdemeanor with a or a $500 fine. We would also be agreeing to a restitution to be paid in the amount of $306.84.
So that's the nature of the offer. Mr. Harris, how are we proceeding today?
Your Honor, my client has indicated he would like to follow that offer.
All right.
Did you mention?
All right. So anything else regarding the offer? I have an added, so it's an added count 2, amended count 2, I should say.
Okay, I believe, Your Honor, there was also a Killebrew agreement to no further upfront jail.
That would be correct, Your Honor.
Okay, so Killebrew. And I will add a count 2. So we'll add a count 2 of embezzlement under $200. All right. So my understanding of the plea offer is upon successful plea and sentencing to count 2, count 1 is to be dismissed. The plea is to the added count 2 of embezzlement under $200 under 750.1745. It's a 93-day misdemeanor and or $500. Restitution is the amount of $306.84. And there is a Killebrew agreement between the attorneys of no upfront jail. Is that a fair statement, Mrs. L?
It is, Your Honor.
Mr. Harris.
It is, Your Honor.
May I inquire of your client of his advice of misdemeanor rights?
Yes, Your Honor.
You understand, Mr. Cooper, that you are going to plead guilty to the embezzlement under $200, punishable by 93 days and or $500. What comes along with that misdemeanor plea is these certain trial rights, and I'm going to walk you through those rights, all right? You have the right to be tried by a jury, to be presumed innocent until proven guilty, have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, the questioning witnesses are brought against you. You are represented today by attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court order any witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been placed on the record. The threat said was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the misdemeanor count of embezzlement under $200. Is it your wish today to waive your jury trial rights and plead guilty to the embezzlement under $200?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I swear.
All right. I'm going to bring your attention back, sir, to Speedway, which is 3625 South Cedar Street in the city of Lansing, Ingham County. Were you working at Speedway or an employee or servant agent of Speedway on January 29th, 2024, at 3625 South Cedar Street in the city of Lansing, Union County?
I was.
All right. And at that time, did you convert to your own use funds that were available or should be available for Speedway? Did you convert them to your own use less than $200?
I did.
Okay. Why don't you tell me what you did?
Exactly what was said.
Okay. So the cash was for Speedway and you took it and you converted it to your own use. All right. Anything else for the record and that was on Cedar Street in the city of Lansing. Anything else for the record in docket on anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Harris.
No, Your Honor.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. There's a Killebrew agreement here of no upfront jail between the lawyers. If I was going to do anything different, you'd have the opportunity to withdraw your plea. Do you understand that, sir?
I did.
Okay. We're going to refer to probation. We have an amount for.
Your Honor, would you perhaps be willing to consider immediate sentencing?
The only thing about the immediate sentencing, and I'll leave it up to the prosecutor, and I see she's got the red page, is the restitution in this matter, because the restitution is $306.84 to Speedway. If you're confident that's the rest that restitution is good, we can go ahead and go to immediate sentencing. If not, I mean, I'm going to have probation look into it.
We are confident in that amount, Your Honor. The police report was submitted with a receipt as well that
All right.
shows the correct amount.
Do you have a date? Do you have the amount of times in jail spent by Mr. Cooper on this charge?
Your Honor, I don't know his jail credit off the top of my head. However, I do note back on March 4th of last month, my client was sentenced on a probation violation in front of Judge Jamo at 30th Circuit to 365 days, credit 119. So I would be requesting time served on this case.
All right. He did make bond. There's a 1,010% bond on this matter. So, and I don't have it that he's made bond. He's been incarcerated. There was a hearing in circuit court on March 3rd. Let's see if we can figure out what.
I'm working on it.
Yeah. Let's see if we can figure out something to put down in regards to the jail credit.
Yes.
All right.
So he would have appeared on this case for us automatically on February 25th.
My client has indicated he's been in custody since he was arraigned on the charge.
I understand, Mr. Harris, but he PR'd on this case.
Okay,
After 5 days, it's an automatic PR.
understood.
So he has 5 days on this case, but if he's serving a sentence for another judge.
All right.
And he has been in custody, he could have been released on February 25th on this charge.
All right. And I think there's
Let me see.
how many days does he have completed in?
If I was working on that next. Um, 38 days, Judge.
38 days. All right, so any allocution concerning this matter, I have a pink sheet which indicates the $306.84. Any allocution on this matter, Mr. Harris?
Your Honor, we would simply request that the court sends my client to time served. As I mentioned, he was recently sentenced to 365 days credit for 119. That's even the remaining balance is still likely far higher than the maximum total amount he could sentence on. He could be sentenced to on this case, so we would be requesting time served.
All right, thank you. Mrs. Zell, any comment on the restitution or sentencing on this matter?
Your Honor, we believe that even a period of probation may be helpful to get that restitution amount paid for. We understand that Mr. Cooper has spent some time in custody And we recognize that, and we have heard from the victims today, and the victims have talked to us about how Mr. Cooper was not a bad employee, was not a bad person, just had a lapse in judgment. So we would leave the rest of it to the court's discretion.
All right, Mr. Cooper, is there anything you'd like to say to the court before the court passes sentence?
Good night.
All right, thank you. I'm reluctant to put him on probation, obviously, if he's still got a year left on time to go. So let's clean up this file while we have the chance. So this is for a guilty plea that was set for today. I'm gonna say that 30, so jail credit for jail is 30 days in the Eaton County jail, credit for all time served, so time served on 30 days. That'll be 4 or 5 days for us, and then additional time served on the additional case. So there's no additional jail time. I'm not going to refer to probation because there's still an ongoing sentence out of circuit court. So there'll be no upfront jail in regards to the Killebrew agreement. Restitution, and I do have a pink sheet or red sheet, depending. Restitution is the amount of $306.84, along with the fines and costs in this matter. Fines will be set at $100 fine, $100 cost, crime victims' rights fee of $75, state fee of $50, for a grand total of $325. And then with the $306 on top of that, that would be 84 cents. I have $931.84, and that'll be all referred to collections. So Mr.
Firm Judge, 900?
I've got let me redo my math. So I've got $325 plus $306 is not $931. I could tell you that right now. It's $631. That sound right?
That was what I came to.
Yeah. $631.84. That will be referred to collections. So Mr. Cooper, as soon as when you get out being incarcerated, collections will have that. Wow. So that you should contact the City of Lansing 54A collection department. They'll refer you to the right person so that you can start making payment on that. Okay, sir?
Understood.
All right. Anything else for the record in 2401070, Mrs. L?
No, Your Honor.
Mr. Harris?
No, Your Honor. Thank you.
All right, Mr. Cooper, you're all set. Thank you for your service.
Thank you.
Then we have Mr. Smith.
Yes, Your Honor.
All right. All right, so we're on the record in docket 25-00291. That is People of the State of Michigan versus Jermaine Smith. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Smith, who is appearing via Polycom from MDOC, Your Honor.
And sir, you are Jermaine Smith, is that correct? You'll have to unmute. They'll have to unmute that iPad, or whatever you're on has to be unmuted. All right, Mr. Smith, you're in the right place. I know you don't have, it's not your fault that you're on mute. So when somebody, you just let them know that they have to unmute that device, and then we'll call the case, because I don't know if they have anybody to unmute the device.
If you like, while we wait, Your Honor, we can handle Mr. Washington.
Mr. Washington, Marco Washington.
Yep.
All right, so we're on the record in 21-03345. That is People of the State of Michigan versus DeMarco Washington. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Washington, who's standing to my right, Your Honor.
And sir, you are DeMarco Washington, is that correct?
Yes, sir.
All right, thank you. This is the time set for a final pretrial in the matter. Ms. Izell, how we proceed?
Your Honor, if I could defer to Mr. Harris.
Mr. Harris.
Oh, actually, I apologize. I am so thrown off right now. At this time, Your Honor, the people are unable to proceed as the witnesses in this case have not appeared. We did send subpoenas to the witnesses and they have not responded to those.
Given the prosecution's inability to proceed, Your Honor, we would be requesting this case be dismissed.
All right, so the complaining victim was subpoenaed. The complaining victim has failed to appear today. So, Mr. Harris, I'm going to draft you to grab that nollie cross for me based on your motion.
Permission to approach?
You may. Thank you. All right, and so I'm in possession of the order of acquittal on nollie based on defendant's motion to dismiss. And that's a dismissal without prejudice, which means that the people could reissue Mr. Washington if they choose to, but for our purposes today, the case is dismissed. All right, sir?
Yes, sir.
So I'll sign the order of dismissal based on your motion. There's no GPS involved. I would give at least the afternoon to make sure that it's purged from the computer system, any pre-trial conditions, okay?
All right.
All right. I will sign the order of acquittal accordingly. Anything else for the record in 21-03345, Mrs. L?
No, Your Honor.
Mr. Harris.
Not for the defense, Your Honor.
All right, Mr. Washington, you're all set. Thank you for your
Thanks.
presence.
I'm just trying to break into my.
All right. So, all right, so let's go back on the record with Jermaine Smith. That's parties have already indicated themselves for the record. Mr. Smith, it's my understanding that as long as you can hear us and you acknowledge that you are Jermaine Lewis Smith, can you give me a thumbs up or you are on mute? No, I don't think I'm not on mute. Everybody else can hear us. But we are not on mute. I think you're on mute.
Yeah, I did see he gave a thumbs up.
Yeah, but I did see. All right. Thank you, Mr. Smith. Just for my own edification, Mr. Lee, can you hear me on your end? You have to unmute.
Yes, I can, Your Honor.
Yeah. Okay. And so our system's working. The Department of Corrections has a problem with their mute system. But Mr. Smith, you've given us a thumbs up on your end. Mrs. L, how are we proceeding today?
Your Honor, at
unmuted.
this time, the people's witnesses necessary for this case did not appear. They were subpoenaed and we have attempted to contact them. However, we have not been able to do so. We do expect a motion from the defense at this time.
Mr. Harris.
Yes, Your Honor. Given the prosecution's inability to proceed with the case, we would be requesting this case be dismissed.
All right. So I will, at the request of the defendants, at the request of the defendant, I will entertain a motion to dismiss or order of acquittal in docket 2500291. Mr. Smith, I'm dismissing at the request of the defendant based on the complaining victim failed to appear, although they've been subpoenaed, and the plaintiff and the people cannot proceed today. This is dismissed without prejudice, Mr. Smith. which means that people could reissue if they choose to, but realistically, for our cases today, the case is dismissed. All right, sir? All right. Anything else for the record in 25-00291, Mrs. L?
Not for the people.
Mr. Harris?
Not for the defense, Your Honor.
All right. Thank you for your appearance today. You should be all set. This case is dismissed, Mr. Smith. So, David Lynn, Blake Cornell, Derek Lampman, and Calvin Copeland, your attorney will meet with you in just a second, and then we'll place you on the record, all right?
All right. Yeah, I was gonna say, could I speak with him for a brief moment?
All right, thank you.
Thank you.
All right, Jasmine Sullivan, what case are you here on?
I'm here for David Land case.
For you're here for Lynn?
Yeah.
All right. So that's Paris Lynn you're here for. You're in the right courtroom. I'm just making sure I know who's in here. All right, ma'am?
Okay.
All right. Oh. Mr. Harris, who did you want to see?
If I could speak with Mr. Lampman next, Your Honor.
All right. So you can go back to court. You can go back to room 3, and Mr. Lampman should be in room 3. And then, Mr. Lee, what case are you ready on?
We are ready to proceed on Kelvon Copeland and Stephen Newton, Your Honor.
So I can go on with Mr. Copeland. All right, so we're on the record in docket 24-03397. That's People of the State of Michigan versus Kelvon Copeland. Will the parties please introduce themselves to the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Kelvon Copeland.
All right, and for the record, this was a set for final pretrial in the matter, I believe.
That's accurate.
Oh, dude. It's your docket.
Yeah.
I don't know what I did with my docket. It just had
I
it.
can make you one if you need that.
So, let's see if I can. Here it is.
First off, Your Honor. Hello.
All right, so we're on the record and on Mr. Copeland, this is set for final pretrial. I've given Mr. Copeland the opportunity to come via Zoom. He should have been here by via person. I'm looking to see if there was any indication that that I okayed Zoom. Mr. Copeland's indicated he is here by Zoom. Mrs. L, how are we proceeding today?
Your Honor, it was my understanding that we would be extending a plea offer today of a breach of peace civil infraction. And was my understanding that Mr. Copeland was planning on accepting that offer. However, I'm not sure how that can occur while he's on.
Well, if it's a civil infraction, Mr. Lee can take responsibility for Mr. Copeland.
Yes, sir. And we
so-
apologize for his appearance on Zoom. Your Honor. He has been here.
I do apologize, Your Honor.
3 different final pretrials in person. He suffered a bug bite and was going to go to the emergency room this morning and thought he would appear via Zoom and try to make
All right.
something happen.
All right, is that understanding? We're doing a breach of the peace civil infraction. That's $150 fine. I believe that's $150.
I believe so, Your Honor.
Oh wait, so in that one, we'll amend count 1 to civil infraction of breach of peace. And that comes with a $150. That comes with a $150 fine. Is that your understanding, Mr. Lee?
Yes, it is, Your Honor.
Mr. Copeland, is that your understanding? Mr. Lee will be accepting responsibility on your behalf for the civil infraction of breach of peace.
Yes, Your Honor.
All right. All right.
Also-
Go ahead, sir.
Sorry. No, I'm not exposing myself, but I got bit. I don't know what I got bit by, and I'm on my way to the emergency.
You're fine. All right, you're fine, Mr. Copeland. Due to the resolution here, I'm going to give you what you need to pay, the $150. And does your client need some time to pay that?
He would ask for 90 days.
All right. All right. All right. So let me take the responsibility. So just we're working from the same facts. This is for a conduct which occurred on April 30th, 2023 at the offense location in the city of Lansing. That was on Sadie Court in the city of Lansing. Do you accept responsibility on behalf of your client for your client being in breach of the peace civil infraction, Mr. Lee?
I do.
All right. And that comes with a $150 fine. 90 days to the city of Lansing would be presented. That should be paid in 90 days. And I'll get you a date for that.
June 30th.
June 30th. June 30th, 2025. $150. So, Mr. Copeland, it'll be $150 to the city of Lansing by June 30th. You can make up any payment plan you want as long as it's all paid by June 30th, 2025, $150, and they can be paid online, in person, or by phone. All right, sir?
All right.
All right. Anything else for the
I gotta
record in 24-03397, Mrs. L?
No, Your Honor.
Mr. Lee?
Nothing further. Thank you.
All right, you're all set, Mr. Copeland. June 30th is the date for the fine. Thank you. So you should be all set, Mr. Copeland.
All right.
All right, Mr. Newton, we'll call your cases. All right, so we're on the record in docket 2202. I'm sorry, 25-00500. 25-00501. And 25-00502. That is the people of the state of Michigan versus Stephen Newton. Will the parties please introduce themselves to the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Stephen William Newton.
And sir, you are Stephen William Newton, is that correct?
Yes.
And you can hear me all right, Mr. Newton?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, there has been evidence shown to us of compliance for the dog license and compliance for the dog at large. Unfortunately, my files are not separated, so I'm not sure which of the files those are on, but we would ask for those two counts to be dismissed. And we would ask for the vicious dog count to be set for a final pretrial.
Right. Is that a fair statement, Mr. Lee?
It is, Your Honor. I show the vicious dog file to be 501.
All right. All right, so dismissed for compliance. The unlicensed dog. So the unlicensed dog 25-00500 is dismissed. And the dog at large is dismissed for compliance. And that is 25-00502. And then we will set it for final pretrial. Did you indicate, Ms. Newton, on the 25-00501?
Yes, Your Honor.
All right, so we'll set for final pretrial on
April 22nd at 8:30.
April 22nd at 8:30. All right, so we've set 25-00501 for final pretrial on April 22nd at 8:30. And Mr. Newton, you receive notice at that Kilbourne Street address. Is that still a good address for you, sir?
Yes, Your Honor.
All right. Anything else for the record in 25-00501, Mrs. Zell?
Not for the people.
Mr. Lee?
Nothing further, Your Honor.
All right. Mr. Newton, you're all set. We'll see you on April 22nd at 8:30.
Okay, thank you.
You're welcome. I have on And then, Mr. Cornell, you've spoken to the public defender, Mr. Harris.
Yes, sir.
All right. And Ms. Lawless, you have not spoken to the public defender, is that correct?
Yes, Judge.
All right. Miss,
Oh, no, never mind.
I don't know what you're talking about. Ms. Lawless, I'm gonna put you in a room with a public defender when he joins us. All right, ma'am?
Okay.
Yes, excuse me, Your Honor.
Mr. Harris, did you want to meet with Paris Lynn, or do you met with?
Yeah, I have spoken with Miss Lynn briefly. If I could just have a brief moment to talk with her and then to talk with Miss Lawless. Thank you.
All right. I think Mr. Lee is gonna, Mr. Lee was planning on meeting with Miss Lawless. I'll put you in a room with Miss Lynn, and then we'll see who shows up first on, because I'm waiting for Mr. Lee. He was talking to somebody in the back room, but I'll put you in a room with
Understood, Your
Miss.
Honor.
All right. So you should get a prompt to go to room 2. All right, so we're on the record in docket 22-02822. Twenty-two zero two eight two two. Two eight two two. 22-02823. 22-02824. 22-02825. And 22-02821. This is people of the state of Michigan versus Randall Schaub. I have 5 dog cases. 6. 3, 4, 5 dog cases. Appearances for the record, Mrs. L.
Gabrielle Lezell, Assistant Prosecutor for the people.
And sir, you are Randolph Schaub, is that correct?
Yes, sir.
And you are not represented by counsel today, is that correct?
Right.
They're asking for bond to be reinstated.
Match or whoever arranged them ordered the bond to be reinstated. It just did not get done, so we have to give it back to the county. Judge Ward ordered it reinstated.
Right, so bond was set at $100 PR. That's what the initial bond was set.
I had a bond out once over.
Did you pay money?
Yes.
How much did you pay?
I think it was like $250.
Yeah, I don't.
It looks
Bench
like-
warrant, oh, you were bench warranted, bond was forfeited. And then I have reinstate the original bond. So bond was forfeited as of February 24th on the amount you paid for the bench warrant, I would assume. So, all right, we'll do that at the end. We'll take care of this and then we'll do that at the end. It looks like the original bond is to be reinstated. We'll do that. Okay. Mrs. L, how are we proceeding on 5 of these files?
Your Honor, at this time, we would ask for all of 5 files to be set for a final pretrial so that we have an opportunity to speak to Mr. Schaub to try to work out a resolution here.
All right, Mr. Schaub, is that a fair statement? We'll set them all for final pretrial and that give you the opportunity to speak to Mrs. L.
Yes, I just might tell you, I've been in this courtroom probably 3 to 4 times and been to jail like 2 times over dog tickets.
All right.
I'm tired of it.
Yeah, I certainly understand that. They're getting to be expensive dogs.
Yeah.
So let's set for final, I'm gonna reinstate the original bond. And the original bond was a PR bond. So $100 PR is reinstated. PR. So I'm just reinstating the personal recognizance bond on these tickets. And then we'll set for final pretrial.
April 29th.
April 29th at 8:30. So Mr. Schwab, if you're able to negotiate this down, just contact Mrs. L and then we'll go from there. That'll give you some time to work through any of these conditions or see if there's any compliance to be met. So I'll set for final. So we'll set for final pretrial on all the files for April 29th at 8:30. Let's make that live in person, just like we are now here. So there's no misunderstanding, and you'll get notice from my court officer for these files. Anything else for the record in docket 22028222, 23, 24, 25, or 21. Mrs. L.
Not for the people.
Mr. Schaub, you should be all set. We'll see you on that April 29th date at 8:30.
Thank you.
All right, Mr. Lamman, we'll call your case. We're on the record in docket 25-00427. That is People of the State of Michigan versus Derek Lampman. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Lamman, who's appearing via Zoom, Your Honor.
And sir, you are Derek Lampman, is that correct?
Yes, sir.
And you can hear me all right, Mr. Lampman?
Yep.
All right, thank you. This is the time set for a final pretrial in the matter. I do have indication from the previous hearing that Zoom is appropriate for this hearing. Mrs. L, how are we proceeding?
Your Honor, at this time, we would be asking for this to be set for a jury trial.
Is that a fair statement, Mr. Harris?
Yes, Your Honor, I've communicated the people's offer to my client, and my client is requesting to have this set for jury trial.
All right, jury trial set for?
May 13th at 8 o'clock.
May 13th at 8 o'clock. So I'll have jury instructions a week prior to May 13th at 3 o'clock. Anything else for the record in 25-00427, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Mr. Lampman, we'll see you here live in person on May 13th at 8 o'clock. All right, sir?
All right. Thank you.
Thank you. Mr. Harris, who else did Mr. Cornell?
Yes, I'm ready on Cornell.
All right, Mr. Cornell, we can unmute.
Yes, sir.
Right, so we're on the record in docket 25-00670. That is People of the State of Michigan versus Blake Alexander Cornell. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Cornell.
And sir, you are Blake Cornell, is that correct?
Yes, Your Honor.
And you can hear me all right, Mr. Cornell?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding today, or would you like to defer?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial. I'll defer to Mr. Harris for any additional information.
All right, Mr. Harris, we're setting this for final pretrial. Any additional record you'd like to make?
Yes, we will be requesting a final pretrial. I understand negotiations are continuing. My client has indicated that he has a substance use assessment. He is scheduled for next week, which may also be beneficial for negotiations. And so we would be requesting this be set for a final pretrial, maybe in about 30 to 45 days to allow time for that assessment to.
All right, I think we're scheduling past or around that realm anyway.
April 29th.
So we'll set for April 29th at 8:30 for final pretrial, which is in the realm of 4 weeks. So we'll set for April 29th at 8:30 for final pretrial. Can that? Do you have anything other than law enforcement for that concerning that? Because we could do that by Zoom if there's nobody else. If that's not.
I believe it's just law enforcement.
Yeah. So, Mr. Harris, would Zoom be appropriate for that?
Yes, Your Honor.
All right. I find Zoom appropriate for that final pretrial. So, Mr. Cornell, you can attend by Zoom. We've set a final pretrial on April 29th at 8:30.
Yes, sir.
Anything else for the record in 25-00670, Mrs. L?
Yes, Your Honor. We've actually run into a little bit of a hiccup in this case. It appears that the people charged this case with 2 counts, an OWI and then carrying a concealed while under the influence. However, it appears that in the court system, only 1 charge had carried over. We were wondering if we could get any insight into that.
That is correct, Your Honor. When I was going over some possibilities of an offer with Mrs. Zell last week, there was mention of a count 2 that I didn't see in our systems or on the court's docket. When I went and looked in at the original complaint that we received from the prosecutor's office, there was a count two listed. We both decided we would try and inquire to see what may have
Right.
happened regarding that count two.
I have the count two. He was arraigned on the count two because it's part of the file, but let me check the computer system. Is there a count two on the computer system?
There's not, looks like it was a clerical oversight, which we can easily correct this afternoon.
All right, so we'll correct that. We'll correct that to add the count two of CCW, carrying concealed while under the influence. It was a part of the complaint, so I'm assuming that was part of the arraignment, that the magistrate arraigned on both those, on both, whatever counts were on the complaint. But the computer doesn't reflect it, so we'll make it right. Anything else for the record in 25-00670, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, thank you. Mr. Cornell, we'll see you on April 29th at 8:30. You should be all set. And then that's.
All right, thank you, Your Honor.
You're welcome. Then we can call David Lynn, and that would be Paris Lynn. Is that correct?
Yes, Your Honor.
All right, Miss Lynn.
Yes, I'm here.
All right. We're on the record in docket 25-00694. That is People of the State of Michigan versus David Lynn. Will the parties please introduce themselves for the record, Mrs. L?
Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of my client, she goes by Paris Lynn. I understand that is the name on the docket. However, she has indicated to me, and I see, and so I know from our arraignment that my client prefers to go by she, her pronouns, and Miss Paris Lynn as the preferred name.
All right, thank you. And so, ma'am, your legal name is David Lavelle Lynn. Is that correct?
Yes, correct.
All right, and you have a preference for Paris Lynn as your preferred and a she as your preferred pronoun. Is that correct?
Yes, correct.
All right, thank you. This is the time set. So, Paris Lynn, can you hear me all right?
Yes, I can.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, we'd ask for this to be set for a final pretrial.
All right, is that your understanding, Mr. Harris?
Yes, Your Honor, that is my understanding as well.
All right, so we'll set Ms. Lynn's final pretrial for
April 29th at 8:30.
So we've set the final pretrial, Ms. Lynn, for April 29th at 8:30. Is that Shiawassee Street address still a good address for you?
Yes, correct.
All right. That'll be live in person on the 6th floor City Hall of Lansing, unless I hear differently from the parties. Anything else for the record in 25-00694, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right, Ms. Lynn, you're all set. We'll see you on April 29th at 8:30. All right, ma'am?
Okay, thank you.
You're welcome. And Mr. Lee's met with Miss Lawless. All right, Miss Lawless, we'll call your case. So we're on the record in docket 25-00598. That is People of the State of Michigan versus Veronica Lawless. Will the parties please introduce themselves to the record? Mrs. Up.
Gabrielle Izell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Veronica Lawless.
And ma'am, you are Veronica Lawless, is that correct?
Yes, Judge.
You can hear me all right, Miss Lawless?
Yes, Judge.
All right, thank you. This is the time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people have been provided with evidence of compliance of the law. At this time, we would ask for this case to be dismissed based on compliance.
And that's your understanding of Mr. Lee?
Yes, it is, Your Honor.
Is this on a ticket? It is. All right. For compliance purposes, the case is dismissed without prejudice. Ms. Lawless, this means that people could reissue if they choose to, but realistically today, that's a default position. The case is dismissed for compliance purposes.
Okay.
Anything else for the record in 2500598, Mrs. L?
Not for the people.
Mr. Lee?
No, Your Honor.
All right, Ms. Lawless, you're all set. Do you have any questions of me?
No, sir.
Okay, you're all set. Thank you for your appearance today.
Thank you.
On the record in 25-00857, that is people of the state of Michigan versus, is it Indy Taylor or India Taylor? India Taylor. India Taylor. Will the parties please introduce themselves for the record, Mrs. L?
Gabrielle Zell, Assistant Prosecutor for the people.
And ma'am, you are India Taylor, is that correct? All right. And you are not represented by counsel today, is that correct?
That is
All right. This is a time set for a pretrial in the matter. You've had the opportunity to speak with the Assistant APA, Mrs. L. Mrs. L, how are we proceeding?
Thank you, Your Honor. Yes, I did have the opportunity to speak to Ms. Taylor today. We spoke about the charge that she is currently charged with, which is a misdemeanor malicious destruction of property under $200. We also discussed the fact that Ms. Taylor has already paid the victim in the case for the damage that was done. A receipt was produced by Ms. Taylor and was confirmed by the victim in the case. At this time, we are extending an offer to Ms. Taylor to take responsibility for a breach of peace civil infraction with a $150 fine. And upon taking responsibility for that, we would be dismissing count 1, the misdemeanor of MDOP.
All right. So that essentially we can add a count 2. All right, so Ms. Taylor, you understand the offer by the people of the state of Michigan is that account 2 of what is a civil infraction of breach of the peace. It sounds like restitution has already been worked out between the parties. That would be a $150 fine to the city of Lansing. Civil infraction is less than a misdemeanor, so it would be like a speeding ticket, but it's not abstracted in any way. What is your decision to take the offer from the people of the state of Michigan or to set this for final pretrial?
Yes.
Okay. All right. So you're going to take responsibility for the breach of the peace added count 2. Is that correct? All right. So I'm going to bring, just so we're working from the same fact pattern and make sure we have the same. This would all occurred on March 21st, 2025. March 21st, 2025, at the offense location of 206 East Malcolm in the city of Lansing, Ingham County. You accept responsibility on that date and time in the city of Lansing for being in breach of the peace. Is that correct? All right. And do you need some time to make that $150 fine to the city of Lansing?
Nope, I plan on paying it as soon as I leave from out of this one.
So you can pay today? All right. All right. So it'll be paid to the city of Lansing. We'll make it by 4 o'clock today and you can pay when, but so that would be April 1st. That's already April 1st. And you can pay at the counter, ma'am, okay? All right, I'm also in possession of the nollie pros for count 1, which is the malicious destruction of building, a 200 to 1,000. It appears restitution, as indicated, has already been worked out. And so I will sign the motion for dismissal without prejudice. Anything else for the record in 25-00857, Mrs. L?
Not for the people.
Do you have any questions of me, Ms. Taylor?
No.
You're all set. Thank you for your appearance.
Thank you.
I have Richmond, Slater, Shabazz, Ruffin, and Harriman. That sound right?
That's what I showed.
Richmond, Slater.
Ready to go on Mr. Shabazz, Your Honor.
All right. Let's go on Shabazz.
Okay. Okay.
I have Shabazz on for review or a bond. I scheduled for review.
Yes, Your Honor, this is a little bit of a complicated scenario. I do show he has a state case for a theft charge where he failed to appear and a bench warrant was issued. There was also a felony case represented by someone in my office where he failed to appear at the PCC and a bench warrant was issued. When he failed to appear at this pretrial, I see a note that there was a request to set it for review for today. I see last week on Friday, he was picked up on the 2 bench warrants and given, I believe, cash surety bonds. And it seems, according to the ICJ roster for today and yesterday, as well as VineLink, that he may have managed to post those bonds as he is no longer listed as in custody.
So I have on February 28th, the defendant didn't appear or contact probation for a second time referral. He had arraignment scheduled on February 25th. He failed to appear for another case. And then I was requested, would you like to issue a warrant? I said I would issue a warrant, and then I set it for review. First failed to appear on March 18th. We set it for review with the understanding, and now we don't know where he is, right?
Yes, it sounds like late last week he was picked up on at least two of the at least the warrants on the other cases. I don't know if he was arraigned on the warrant on this case, but he was picked up, arraigned on 2 of the warrants and given cash surety bonds, and so seems like he may have posted those.
So there is a warrant out on 22-00977.
Nope, he said to hold it and to set it for
All right.
review today. We
All
did
right.
not issue that day.
All right, so let's go ahead and issue the warrant on this file. Since we've lost track of Mr. Shabazz on some level. So I'm going to indicate that D is FTA. This was scheduled for,
Can you call the case for me?
yeah. So this was scheduled for 10 o'clock. It is now 10:27 on docket 22-00977. That is People of the State of Michigan versus Micah Shabazz. Appearances for the record, Mrs. L.
Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Shabazz, who unfortunately is not here in person. When I saw that he had seemingly bonded out of ICJ, I tried to give him a call to advise him to see if he had maybe simply missed this court date or did not have his paperwork when he got released. There was no answer. I left a voicemail, but I have not been able to make contact with him since.
One of the reasons that so we set this for hearing, you failed to appear on March 18th, and then I did not issue a bench warrant. I don't know why, but the PA 53 scheduled for review, and might have been that he may have been in, or we thought he was in another jail because he'd previously been in Clinton County. Regardless, wherever he is, he's got a bench warrant for him now. So defendants failed to appear. It was scheduled for 10 o'clock. It is now 10:28. And we'll issue a bench warrant. D failed to appear. I also have this for a PA 53 violation, a no contact violation. Is that correct, Mrs. L?
I believe that is correct, Your Honor.
So I'll issue a bench warrant and bond forfeiture. Because he's got numerous failed to appears, at least 3 that I can count on this file. And this is a domestic violent assault. I'll issue a bench warrant bond forfeiture in the matter. Any comment on that, Mr. Harris?
No, Your Honor, I will leave it to the court's discretion.
All right. So we'll issue bench warrant bond forfeiture for the defendant's non-appearance today on file 22-00977, and then wait his appearance once we find out where Mr. Shabazz is. Anything else for the record in 22-00977, Mrs. L?
Not for the People.
Mr. Harris.
Not for the defense, Your Honor.
All right, we should be all set on that file. And then we can do the Harriman file. All right, is anybody here on Ruffin? right. So it's Amanda Harriman, all right. And then, sir, you're the victim in the case, I believe. Is that correct? You are James David Harriman?
Yes, sir.
All right, you can come up here. You can sit next to Miss Azell. And then Miss Harriman, you can sit right there. Right, so we're on the record in 24-00032. That is the People's State of Michigan versus Amanda Harriman. And appearances for the record, Mrs. L.
Gabrielle Ezel, Assistant Prosecutor for the People.
All right, and sir, you're the victim in this matter, and you are David James Harriman, is that correct? James. Okay, James Harriman. And ma'am, you are Amanda Harriman, is that correct? All right. So we're on the record in this matter, and I called this because we're gonna have a modification of the no contact order, but I want it placed on the record, okay? And that's why we're here. Mr. Harriman, it was indicated that due to owning and operating a business, that you are respectfully requesting that the restraining order or the no contact order, which has been a part of the file since arraignment concerning yourself, be dropped in this matter.
Yes.
And all contact be peaceful. Is that a fair statement? Okay.
Yes.
All right. And Ms. Harriman, you're requesting the same? Okay. So it's on the record as to why, and I don't want to get into your personal business on the matter. This did start out as a domestic violence case, and there's been a no contact order since January 5th of 2024. Mr. James Harriman is requesting that the no contact order be lifted. Ms. Harriman, you're also requesting the no contact order be lifted. And we wanted it placed on the record. Of course, the no contact order is to protect the victim in the matter. But there is a relationship here in regards to that they're both involved in operating a company for General Motors. Is that correct?
Yes, sir.
All right. Is that a fair statement, Ms. Harriman?
Yes.
All right. All right. And so I am going to modify the bond. Modify the bond, and I'm going to lift the no contact order at the request of the victim. Of complaining victim James Harriman. And then any further contact should be peaceful in nature. All right. So the no assaultive behavior in regards to Ms. Harriman, that stands, but it will be only peaceful contact in regards to Mr. Harriman.
Yes.
All right. Okay, so it's placed on the record. Any lifting of the no contact order has been done at the request of the complaining victim, which modifies the bond. Ms. Harriman, I would wait for the system to purge because it's had a no contact order that's being modified to only peaceful contact, and it will take about a day for it to make sure. Just so you know that, all right? That's for your own protection. All right. Anything else for the record in 24-00032, Mrs. L? Do the people have an opinion on the no contact order and the modification in this matter?
We believe that the court has done their due diligence here and has done the just and right thing.
Okay, thank you. All right, Mr. Harriman, this is done at your request. We modified the bond so you can have peaceful contact. All right, sir?
I appreciate it.
All right, thank you. You're all set, Ms. Harriman. Thank you.
I'm about to give her a hug now.
Yes, I would say that's peaceful.
I would say that as well. I'll see you later, okay? Thank you.
Thank you. We don't have anybody here on Ruppin, do we?
I don't believe so.
But I don't know if we need anybody here, but let's save that. And then how about on Richmond and Slater? Are those FTAs?
Richmond is one that we need to go on the record
All right.
simply about a stipend order. to
That's the
adjourn.
one. Okay. All right.
I'm not sure about Slater.
Slater
All right.
appears to be an FTA.
All right. We'll call it, let's go on Richmond. And I was saving this there. So we're on the record in docket 2402-377. That is people of the state of Michigan versus Michael Richmond. Will the parties introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
I'm Mr. Richmond, I don't think.
Oh, is Mr. Harris on that case?
Your Honor,
Yeah,
yeah, our understanding from our case notes was, the understanding I see from our case notes in here is that there was we requested a conflict counsel, and there was an indication that Daniel Sturdivant took over as conflict counsel. And then I understand there was I believe there was a stip and adjourn.
There is. It was signed by Mr. Watson.
Adjourn.
Yeah.
And
So the big guy signed the big guy signed that. I shouldn't say the big guy. Keith Watson, the public defender, signed the stip and order to adjourn. And I guess that's why we're here. Okay, that why we're here is Mrs. L's indicating that this was signed. Keith Watson signed it. I think that was probably an error on some level, or maybe not. I don't know. But Mrs. L's indicating she did not agree to an adjournment. Is that correct?
that is correct, Your
But you
Honor.
have no objection to an adjournment.
I do not, Your Honor.
Okay. So the stip in order to adjourn was signed by Mr. Watson. It appears Mr. Harris or Mr. Lee, I've had to read the notes to figure that out.
Yes, it is my understanding this was never assigned to any attorney in our system, because we realized that there was a conflict check, and as far as I can tell, the admin and paralegals of our office may have been handling that conflict check and how it was resolved.
Right.
I don't see any notes about it ever being assigned to someone at our office.
And so Mr. Sturdivant is the perceived conflict counsel,
Yes.
and he should be probably signing the adjournment. But I think he's filed an appearance yet.
Yeah, he just filed it
Yeah.
yesterday.
He filed it yesterday. All right. All right. So I don't think I have to sign the adjournment. I think we just placed it on the record that it's obviously adjourned for conflict counsel. But I do think Mrs. L's doing the right thing by bringing it to the attention and saying I didn't sign that. So if it's got my name on it, it's not supposed to have my name on it. This is a way of clearing it up. So I'm going to indicate that per Mr. Richmond, this has been adjourned for conflict counsel. Of course, Mr. Sturdivant, if he just filed his appearance yesterday, that's going to be problematic for him to get on board with it. So adjourn for conflict counsel. And I will indicate that my understanding is conflict counsel at this time is Daniel Sturdivant, who I believe was with the Eaton County Public Defenders now in private practice. I believe that's correct. Yeah.
Yeah, I have no reason to dispute that.
Yeah, I believe he was with the Eaton County with that office, and now he's in private practice. So we will adjourn and set a new pretrial conference for
April 29th at 9:30.
April 29th at 8:30. And since we do have an appearance, we will send any notification to Mr. Sturdivant at his legal address.
9:30, Judge.
At 9:30? Okay. April 29th at 9:30. All right. Anything else for the record in 2402-377, Mrs. L? And I won't sign the stip in order to adjourn. We'll just put it on the record.
Nothing further, Your Honor.
Anything else, Mr. Harris? Thank you for helping us out. The notice will be sent to Mr. Sturdivant as conflict counsel.
Understood, Your Honor.
Thank you. And then let's go ahead and call Slater, George Slater. All right, so we're on the record in 23-02354. That is People of the State of Michigan versus George Slater. Appearances for the record, Mrs. L.
Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of George Slater Jr.
All right, this was a time set for a pretrial in the matter. It was scheduled for 9 o'clock. It is now 10:40. It would appear, I do not see Mr. Slater in the Zoom courtroom or physical courtroom. Mr. Lee, have you had any contact with Mr. Slater?
I have attempted to contact him, Your Honor, unsuccessfully. So, no.
All right. I do see, oh, he's got a prior fail to appear as of August 22nd. So we've placed a 48-hour hold on him before because of the prior fail to appear. Mrs. L, how would you like to proceed?
Your Honor, just for clarification, did you say the bench warrant was already issued after that 48-hour hold?
There was a bench warrant with a 48-hour hold issued on August 22nd, 2023, and then he was arraigned on February 4th, 2025.
Okay, thank you, Your Honor, for that clarification. If we could request a bench warrant to be issued in this case.
The court will issue a bench warrant and bond forfeiture. Any comment, Mr. Lee?
No comment.
All right. All right. That's all for the record for fail to appear. Bench warrant and bond forfeiture is issued for Mr. Slater. Then Ruffin, and I just think, do you have anything on that?
Not.
Do you have it? So I think it's just a yay or nay from you. This is what I have from Sean. Motion on application to set aside conviction scheduled for April 1st at 10. Scale form does not require MSP criminal history report, proof of service, or attorney general's opinion. Because it's a previous possession of marijuana.
Right.
A prosecutor has 60 days from date of filing to object to application. If no objection, court may grant motion on 61st day from filing under the Michigan Clean Slate Law. No personal appearance required from any party if prosecutor does not object to the application, which we haven't received any, and it doesn't appear that you do.
No,
Okay.
no objections.
An application is pro per. This file is consolidated with J961546 SM in the interest of judicial economy. I think Sean came and talked to me about this. I think they filed twice.
Okay.
I think it's just a pro per that filed twice. So we're on the record in J941407. That is an order and application to set aside a State of Michigan versus Christopher Ruffin. Appearance for the record, Mrs. L.
Gabrielle Ezel, Assistant Prosecutor for the people.
Okay, it's my understanding, Mrs. L, that based on any research that you've done, that the people are not filing an objection to the order on application to set aside. Is that correct?
That is correct, Your Honor.
Okay. So with that understanding, I will indicate for whatever purposes that the hearing was held on today's date concerning that. So I'm going to check box 5 from the order and application and 6. Box 7 is the application is granted for possession of marijuana. And I will sign the order on application to set aside misdemeanor conviction. I'll indicate that the application was granted. The following conviction, possession of marijuana, is subject to expungement. We have a hearing on April 1st, 2025. It was much of a hearing, but the prosecutor indicated they have no objection, and I will sign accordingly. And it's my understanding under clean slate, that's all we're looking for is the objection from the prosecutor. I don't think the MSP is not notified or the attorney general, but this is kind of the first one we're doing under clean slate. Anything else on the record in J941407, Mrs. L?
Not for the people.
All right, we should be all set on that file. To sign the order. And then We've got what, we've got 3 arraignments this afternoon. A couple of 3 violations of probation. And then 1 sentencing, and Mr. Redding is incarcerated. I think is that yours, Mr. Lee?
I think it's technically assigned to me, but I think that Mr.
Harry's is taking.
I am handling the Reading.
All right. So I'll leave it to you, Mr. Harris, to let Megan know when to go get Mr. Redding when you're ready. And then that's the only sentencing this afternoon. The rest are probation violations on Boyd and Short and arraignments on the other 3.
Your Honor, I have in my schedule a Michaela Porter for this afternoon for a probation violation. Is that accurate, or did
Yeah, I've got
my office make that up?
I've got Michaela Porter for violation of probation
Okay,
at 1:30.
gotcha.
Yeah.
Okay, good deal.
I've got Cedric Boyd, Michaela Porter, and Mark Short.
Yes, and I am on the violations for Boyd and Short.
All right. All right. Right, we're all set. Thank you for your assistance today.
Thank you, Your Honor.
I feel like you packed in a morning in 2 hours.
I know.
Yep, well,
Kind of felt longer than that.
yeah, that's how district court is. It's like you do work the hardest you've ever worked for 2 hours, then you're done. And you're like, okay, now we got to prepare for the afternoon. You know? That's just the way it is.
purpose. Police eyes were already on. Got shot in the shoulder. From that moment forward, I always wanted to keep her for a while, maybe like 3 or 4 months straight.
Sir, on iPhone 3, can you identify yourself? And there we go. All right. All right. So let's go ahead and call that case, and then we'll go on Mr. We can adjourn that. All right. So we're on the record in docket 22-034-485. That is people of the state of Michigan versus Jalen Redding. Will the parties please introduce themselves for the record? Mrs. Zhao.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Redding, who I understand was not transported from the Macomb County Jail on a writ today.
Maybe I have, all right, so maybe this might be the problem is, yep, he was writ out of Macomb. My understanding is he also spent time in Wayne County, in the
Yes.
Wayne County Jail.
Yes, Your Honor. My understanding is after he was arraigned on this case, and I believe given a bond in order to report to probation within 48 hours, my understanding is he was transferred over to Wayne for a matter over in Wayne County. And then there was some period, I'm not sure if there was a period where he got out of Wayne and then was transferred to Macomb. I believe he was transferred to Macomb County on March 17th, according to VineLink. So I'm not sure if he was transferred from Wayne County Jail or got out from Wayne County Jail and then was picked up by Macomb.
All right.
All I know is that he ended up in Macomb County.
Right, and we writ him out of Macomb County. And on March, it looks like we writ him out on March 26th. That's the date I signed it. That's less than a week away, so maybe that's why they didn't honor the writ. Because it was presented for signature a week before. Regardless, let's adjourn. So
Thank you.
we'll adjourn. So we know where Mr. Redding is. He's in, the last we heard, he was in Macomb
Yes.
County.
And I believe I checked VineLink yesterday and he was still listed in Macomb County.
So we'll adjourn the sentencing to what date?
If it helps, Your Honor, given the in the original no-show report paperwork we received, it was indicating that he had failed to report to probation to do any of the paperwork. Since it seems like it may not have been his fault he failed to report, I was going to be requesting the court perhaps do a second time referral, and perhaps the probation department would be able to attempt to get in touch with him about in Macomb County about getting that paperwork done.
Yeah, I mean, this goes back to February. He was instructed to be in front of to contact, and they received no information. So they didn't even remember, they don't remember if he was in the, they don't know where he's at, whether he's in Wayne County or Macomb County. Let's just get him here and get him seen by probation, I think is the key. But we're gonna need to get him, and they're gonna have to know where he is. So while he's here, he might be able to be seen by probation. That's the key, is we got to get it on the right. Let's figure out what date we can get him here on.
May 6th at 1:30.
All right, we'll set it for May 6th at 1:30. And then if we have to, we'll adjourn, but we'll get him here so they can do a pre-sentence, because I can't sentence without a pre-sentence. Statutorily, I can't sentence without a pre-sentence. Unless I'm going to give some type of term of incarceration. And I think he'd want to be seen first and talk to the probation agent before I just go and decide that I'm going to be giving him incarceration as opposed to probation. And then they have to develop a report. So we'll see him on May 6th at 1:30 to adjourn the sentencing, and then we'll do another writ. And that should give us time to do the writ so that he gets here without undue delay. I think we attempted to writ him out, and it's too soon. It's like that's in the previous week. So that's well within a week. I don't think that's never worked before, and I don't think it's going to work now. So let's or it's usually not the case. Usually we give same with subpoenas. So we'll reset for May 6th at 1:30. And that's all for the record in 22-03485. And Mr. Harris, if I'm not correct, that was the one sentencing set for today.
Yes.
All right.
Your Honor.
I do have some PV arraignments. I don't know. Did you want to meet with them, or do you want me just to refer them to your office?
I can meet with them to
All
do
right.
an intake paperwork if you'd like.
Did you have anybody you wanted to go before we start those arraignments?
Yes, Your Honor. I do have Mr. Mark Short here.
All
My
right.
understanding that should be rather quick.
All right,
It's not a contested hearing.
All right, let's do Mr. Short. And if I remember correctly, there wasn't a huge recommendation.
Yes, Your Honor.
Right, so, all right. So we're on the record in docket 24-02936. That is people of the state of Michigan versus Mark Short. Will the parties please introduce themselves to the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the People.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Mark Short, who's standing to my right, Your Honor.
And sir, you are Mark E. Short, is that correct?
am.
Thank you.
Thank you, Your Honor.
This is the time set for a probation violation hearing. Mrs. L, how are we proceeding, or would you like to defer to Mr. Harris?
If I could please defer to Mr. Harris.
Mr. Harris.
Yes, Your Honor. I've spoken with my client regarding the recommendation of probation and the allegations. He has indicated that he is going to be pleading guilty to those allegations, and we would be requesting that the court, I can move to allocution for that.
All right. All right, Mr. Short, you understand you have a right to hearing in this matter. You have a right to contest any charges brought against you by the people of the state of Michigan. You are represented today by Attorney James Harris, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Is that correct, sir?
Correct.
It's my understanding it is your wish today to make admission to the technical probation filed by Nathaniel Neves on March 7th, 2025 in this court. Is it your wish today to waive your right to a hearing in this matter and admit responsibility to the technical probation violation?
Yes,
All right, I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, in violation, this is just listed as violation 13, but it doesn't mean there are 13 violations, right? That's just descriptive. It is alleged that per AberHealth, you tested positive for alcohol on March 3rd, 2025. Do you admit to testing positive for alcohol on March 3rd, 2025 in technical probation violation concerning your probation set down by the court?
Yes, I do, Your
All
Honor.
right. All right, I find that the admission for the technical probation violation be knowing voluntarily and accurately made. Mr. Harris, would you like to go to allocution in this matter? And there's a recommendation. I think you've seen the recommendation by Mr. Neves.
Yes, I have, Your Honor, and yes. Regarding this case, I spoke with Mr. Short regarding the allegations. He's been very honest, open, and forthcoming. He realizes he made a bit of a mistake here, and he is trying to take responsibility for that. He's trying to get himself back on the right track. And currently, I think this is very likely to be a one-time thing. He indicates that he's doing well on probation, and it seems, according to the probation officer, that the probation officer believes he has a good attitude and good acceptance of responsibility and is making decent progress. I believe it's described as fair progress in the report regarding his probation. At this point, I would be requesting that the court, simply go with the verbal warning without the weekend held in abeyance. However, I have also explained to my client what the recommendation is and what the weekend in abeyance, being held in abeyance would mean.
Okay, thank you. Mr. Short, is there anything you'd like to say to the court before the court passes the sentence?
Just that I recognize that I messed up, and that it won't happen again.
All right. Mrs. Elder, is there anything you'd like to say on the file before the court passes the sentence?
Your Honor, we would actually agree with the defense. This does seem like a one-time mess up. This does seem like Mr. Short is prepared and ready to continue. We would ask that the recommendation be followed from probation.
Thank you. All right, Mr. Short, everything I've read says that you're a good candidate for probation, and I'm not going to disagree with that. Even your probation agent has indicated that you have a good attitude, but we do have a slip up here, okay? And that's part of it. So I'm going to follow the recommendation to a T, all right? As indicated, with the understanding that this is really a learning experience. Okay, that's what it is. You now know that we're not fooling around, and so you've got to do what you need to do, all right? And this comes from a possession of methamphetamine and an A and B initially, and then you pled to a use of methamphetamine. So you understand right now, we're just trying to make a determination what kind of relationship you're going to have with narcotics and controlled substances, and if it's going to be a positive relationship or a destructive relationship. And right now it's looking kind of destructive. Okay. We have a use of methamphetamine misdemeanor 1-year plea, and then we're having the use of alcohol, which we were told not to use. So prove us wrong. Okay. Prove us wrong. That's the most important thing is that this doesn't have to be a destructive part of your life. It can be for you and the people you love, but it doesn't have to be. All right. All right. So this is the first technical violation. I'm going to look at it as a learning experience. The conditions of probation or substance use education class as directed by your probation officer. Have her held three times a month. There's a current balance is to $669. Continued on probation. Probation ends September 10th of 2025. I'm gonna hold a weekend in abeyance. So 2 days in abeyance is ordered, and that's kind of the, for lack of a better term, a stick. Okay, that is if you know that if you violate again, that's what's waiting for you. That's already been ordered. It's there. But I'm not ordering up front. Okay, it's all held in abeyance. Your probation officer thinks that you are a good candidate for probation. He can work with you. And there's nothing that would suggest different to me. All right. Because you must have better things to do with your time on a Tuesday afternoon than be in 54A district court. All right. Anything might be better than this. All right. All right. So I will adopt the recommendation. I've got two days are held in abeyance concerning the technical violation of probation. The terminations to continue as to September 10th, 2025, and then just keep in contact with Mr. Neves, a pretty fair guy, and so as I think you're getting the feel of, and we want to make sure that you're making good decisions 5 years from now, not just now, 5 years from now. Okay. All right. Anything else for the record in 2402-936, Mrs. L?
Not for the people.
Mr. Harris.
Not from the defense, Your Honor.
All right. Mr. Short, you're all set. Thank you.
Thank you very much, Your Honor.
So, Mr. Lee, do you have Boyd and Caleb Porter? Okay.
I have Mr. Boyd. My understanding is he has not yet appeared.
All right.
Nor views it.
So if you join us, I'll put you in with some of the arraignments. All right. And then you have Miss Michaela Porter.
Correct. Megan? Yes.
I'll let Megan worry about where to put Mr. Harris and what.
Did we ever identify item 3?
No, let's identify. That's a good. Would the person on iPhone 3 please identify yourself? You'll have to unmute on iPhone 3. Could you please identify yourself?
Sierra Porter Miller.
Okay, Sierra Porter Miller, you're here for your probation violation, Raymond. So stand by. We're gonna rename you, and then we'll put you in a breakout room with the public defender previous to going on the record. All right, ma'am? So stand by. All right, so we're on the record in docket 2401795. That is Sierra Porter Michaela. I'm sorry, I said that wrong, I think.
Michaela Sierra Porter.
Michaela Sierra Porter. Is that correct?
Yes.
Michaela Sierra Porter.
It's a little confusing. It's a lot.
It is. It is. The name right before you is Sierra Porter Miller, which completely just throws us all off. So, appearances for the record, Ms. Ezell.
Gabrielle Ezell, Assistant Prosecutor for the People.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Michaela Sierra Porter.
And ma'am, you are Michaela Sierra Porter. Is that correct? Thank you. Thank you. I hope so too. Okay. This is the time set for a probation violation. Mrs. L, how would you like to proceed, or would you like to defer to Mr. Lee?
If I could please defer to Mr.
All
Lee.
right, Mr. Lee.
Thank you, Your Honor. There will be no hearing today. Ms. Porter intends to accept responsibility and/or plead guilty to the probation allegations of 2 positive alcohol tests in February.
All right. All right. So Miss Michaela Sierra Porter, you understand you have a right to hearing in this matter.
Yes, sir.
You have a right to a hearing with and your appointed counsel, Mr. Lee, is here, and he would be present to cross-examine any witness or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am? And it is my understanding you wish to admit to the probation violation. I have violation 13 on 2 dates. Is that fair?
Yes, sir.
Okay. Instead of a hearing, so you're going to waive your hearing rights, and you'll be pleading to being in technical probation technical violation of your probation. Is that what you wish to do, ma'am?
Yes, sir.
All right. I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention back to, this is violation 13, but it doesn't mean there are 13 violations. That just means it's descriptive, okay? In violation of your probation, did you test positive for alcohol at AberHealth on February 19th, 2025?
Yes.
And did you test positive for alcohol on February 21st, 2025? Did you test positive for AberHealth in violation of your probation?
Yes, sir.
All right. I find the violation to be knowing, voluntarily, and accurately made in regards to the testing positive for alcohol. Number 13. All right, Mr. Lee, did you want to be heard on allocution?
Thank you, Your Honor. Ms. Porter is a sincere, hardworking mother of 4. She has been participating in probation. Yes, she had these positive results, but we know of the positive results because she shows up and takes her tests. She is in fact starting therapy sessions tomorrow. She will be participating in AA and counseling. She also intends to utilize the employee assistance program through General Motors, where she has been working now for a little better than a year. She asked the court to have leniency on her, as this is her first violation, and she is aware of the challenges that she has with alcohol and is trying to address them. On this particular occasion, her mom's birthday is February 21st, and it was around the time of her mom's birthday. Her mom passed just a few years ago, that she got depressed and made a bad choice to use alcohol as a coping mechanism. She understands that's not how she can go forward. And as I said, she's fighting the good fight. So we asked the court to reinstate her to probation. My understanding is that Mr. Hanna has recommended that her testing frequency increase we concur with those recommendations and ask the court to follow that.
All right, thank you. Ms. Porter, is there anything you'd like to say to the court before the court passes sentence?
Pretty much, I agree with everything he says.
All right,
I
all
just
right.
wanna-
All right, Mrs. L, is there anything you'd like to say to the court?
Your Honor, we are a little concerned about the violations in this case. This is a case stemming from an operating while under the influence. That is a little concerning to us. With that being said, the classes and the AA we think are going to be extremely helpful, and we would agree that probation should be continued. But we would even ask that maybe the consideration of classes be added to probation terms.
Thank you. Well, Ms. Porter, I think we're on the same page, so to speak. For whatever reason, and it's not unusual, so there's no shame in it. There may be something we have to worry about in regards to alcohol, especially getting in a car. Okay, but more than that, this problem is going to be vigilant and fought by yourself and millions of others throughout your lifetime. That's just the way it is. All right, and if it isn't, it should be, because people do this all the time, not realizing that they've drank too much and they get in a car. Okay, I'm more concerned. We can fix that. Okay, I'm more concerned with the amount of alcohol you drink, and you're making good decisions 5 years, 6 years from now. You have to make independent, good decisions, and depending are you going to do this to yourself because it's not healthy for you, or are you going to do this, get in a car and put somebody else at risk? And that's what I'm more concerned about. I'm more concerned about Michaela Porter in the future. Right now, in probation, to me, I can do the ultimate. You're not supposed to get alcohol in jail, so I can put you in jail. Okay. But you and I know the reality of that is you can get alcohol in jail if you really want to on some level. So it comes down to your choices. You have to make good choices. And I think district court can help you do that. I think we have the resources to help you make good choices so that you can use this and you can blame us, okay, for whatever. You can always say, look, I can't partake. I can't do that. Not only do you know that it may not be good for you, but you know that there's also societal pressure or friendship pressure that places you in a position that's not enviable. I know that. Everybody knows that, okay? But this is kind of the test. Can you be without it? Because if you can't, then we really need to invest some resources in it. We really need for a period of time to say, okay, use us, use our help. If you can, then you're on to bigger and better things, and the vigilance is going to stay with you for the rest of your life. All right, that's what I'm hoping this works as making good decisions. I'm not concerned about you now because we can help you. Okay. But I am concerned about 3 or 4 years from now when we're not around and you've got to make good decisions. So I'm going to adopt the recommendation. It's my understanding that counseling's already been set up. Okay. Good. All right. So I'm going to follow the recommendation of the probation department. We'll set testing will be at AverHealth 2 times a month. Your end of probation date is October 7th, 2025. Current balance is $1,340.96. So you'll be continued till that October 7th date. Any additional jail time will not be imposed. All right. We're going to add a sober link or scram for 90 days or 1 time per week PBT or UA testing for 90 days. That's or you can talk with your probation agent about what they're suggesting because they'll pick one of those, and that is Brendan Hanna. Brendan Hanna is a pretty fair guy, okay? So he's going to work with you in any way. So keep in contact with him because that's part of the. You've got a good, fair probation agent, all right? Right now, we know that you've been testing positive because you've tested, okay? And so that should be in one regard, we don't want you to test positive, but you're testing, and that's important to us. Okay, that's important. So continue doing what you're doing. All right. Just this is the time now that you've got to stop testing positive, because if you don't, then we're told you may have a destructive relationship, and that means we've got to really work on that. And let me tell you what I'm thinking on this. All right. I can't cure all the ills of the world, okay? But if you're not drinking, and there is a secondary reason that you're not drinking, we need to cure one ill at a time, okay? So we have to stop the symptom, which is effectively self-medication, and then we have to go towards the all right, why? Why is it necessary? And if we can solve that, then we're on our way to making sure that Ms. Porter has an active, familiar life to all of us, and that you're vigilant and you're doing what you need to do because you have the tools to do what you need to do, right? That's the important part. I can't make the decisions for you, but I can give you the tools to make good decisions. That's how district court can help, okay? We don't help everyone. Sometimes we don't. We get done and we wonder if we helped at all, but we can help you. Okay, we can help you. Please use this as a resource. Okay. All right. So I'm going to follow the recommendation. There'll be no upfront jail, continue testing and sober link, or the PBT for 90 days. Contact Mr. Hanna. I'm following his recommendation. Do you have any questions concerning the violation of probation sentence recommendation, Ms. Porter?
No, sir.
All right, Mr. Lee, any questions concerning the judgment sentence?
No question, Your Honor.
All right, we should be all set. Ma'am, thank you for your appearance today.
Thank you, sir. I appreciate you. Thank you. I appreciate you. God bless you.
So,
Is there anybody else you want me to join on Zoom to talk to anybody?
I don't know.
James just got done with Mr. Ray. I just put him in a breakout room with Porter Miller.
Porter Miller, and then we have somebody on Samsung. I'm going to admit him, but I have that, and then Boyd's not here yet, right? That's him. So we might call that on the Samsung. Could you please identify yourself? You have to unmute. On the Samsung cell phone, could you please identify yourself? You'll have to unmute. I just let you in the Zoom courtroom. Once we find out who's on the All right, so we're on the record in 24-02093. That is People of the State of Michigan versus Cedric Boyd. On the Samsung, could you please identify yourself? You'll need to unmute. You'll need to unmute your cell phone. So we're on the record in People versus Cedric Boyd. Will the parties please introduce themselves for the record? Mrs.
Gabrielle Zala, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Cedric Boyd, standing in for James Harris.
All right, thank you. This was set for 1:30. It is now 2:16. And we do not have a Cedric Boyd in the physical courtroom. There is not a Cedric Boyd in the Zoom courtroom. There is a Samsung cell phone who just recently joined us, who will not identify themselves or does not know how to unmute. But there's nobody by that name in the hallway. Mr. Lee, have you had any contact, or do your notes indicate any contact with your office from Mr. Boyd?
No, Your Honor, we have not been able to establish contact.
All right. It would appear that the defendant has failed to appear for the violation of probation. It was set on March 25th for April 1st this week. Mrs. Zell, how would you like to proceed?
Your Honor, at this time, we would be asking for a bench warrant to be issued in this case.
All right, I think, let's see. He pled to an assault and battery. So, any comment, Mr. Lee?
No comment.
All right. I don't have a previous fail to appear, but this is an assault. He pled to assault and battery. It was an added count 5. And I think this comes out of a multiple felony count assaultive case. Okay. So at this time, the defendant has failed to appear for the probation violation hearing, and a bench warrant and bond forfeiture are issued. Anything else for the record in 2402-093, Mrs. L?
No, thank you, Your Honor.
Mr. Lee?
No, Your Honor.
All right, you're all set. Thank you for your appearance today. And then we'll go on Caleb Ray for arraignment.
I think it's on count.
I think right now Brad is doing really well. That's all.
All right, so Ms. Porter Miller, I'm gonna have you mute until we call your case, since we can all hear you. All right, and on the Samsung, you still haven't identified yourself, so I still don't know who the Samsung is in the Zoom courtroom. But we will continue on the probation violation arraignment for Caleb Ray. I think we have 3 arraignments left. You should be all set. So we're on the record in 2403-510. That is people of the state of Michigan versus Caleb Ray. And sir, you are Caleb Ray, is that correct?
Yes, sir.
All right, this time set for a probation violation arraignment. I will read you the allegations that have been made against you by your probation officer concerning this matter. It is alleged that on or about from Brendan Hanna in a request and summons for probation violation submitted to the court by March 18, 2025, that you did in 1 fail to set up testing file at Pat's as requested by your probation agent, and in count 2, or what's indicated, displayed assaultive threatening behavior on around March 18, 2025, which is a non-technical violation of your probation. So do you understand the 2 allegations that have been brought against you by your probation officer, failed to set up testing file at Pat's and displaying assaultive or threatening behavior? Do you understand that, Mr. Ray?
Yes, sir.
All right. You have the right to a hearing in this matter. You have the right to be represented by counsel. It's my understanding you've recently met with the Public Defender's Office concerning representation. Do you expect to be represented by the Public Defender's Office in this file? You were represented by the Public Defender's Office in the underlying file. Do you plan to seek additional representation on this file, Mr. Ray?
Yes, sir.
Okay. And you had the opportunity to talk to the public defender, so you made application concerning this matter. Is that correct?
Yes, sir.
Okay. So let's set this for formal hearing. And that'll give your public defender, along with the probation officer, some time to talk about the case, negotiate, or to set up things for a hearing. And we'll set formal hearing for
April 22nd at 1:30.
April 22nd at 1:30. All right, Mr. Ray, we've set this from April 22nd at 1:30. You had the opportunity to meet with the Public Defender's Office. If you have any questions, you can contact that office. Anything else? And we've set this for April 22nd at 1:30. Anything else for the record on 2403-510, Mr. Ray?
No, sir.
Right, you should be all set, sir. Thank you for your appearance today.
Thank you.
On the iPhone 3, is that?
That's Porter Miller. I think she just rejoined us.
All right. Miss Porter Miller, are you there? You can unmute. Miss Porter Miller. I think you were on the iPhone 3. All right. Then ma'am, you can unmute. All right. So I'm going to call your case next. You're on the record in docket 23-03570. That is people of the state of Michigan versus Sierra Porter Miller. Appearances for the record. Ma'am, you are Sierra Porter Miller, is that correct?
Yes.
All right. This is the time set for arraignment in the matter. And I'm going to indicate to you some of the allegations that are brought against you by your probation agent. It is alleged on a request and summons for a probation violation on March 24th, 2025, that you did test positive for cocaine at AverHealth on March 7th, 2025. That is the sole allegation made at this time. Ms. Porter Miller, do you understand the nature of the probation violation that is alleged against you by the probation department?
Yes.
All right. You have certain rights in this matter. You have a right to a hearing. You have a right to an attorney. My understanding is you've already spoken to the public defender's office. I believe they represented you in the underlying file, and you plan to be represented by the public defender's office on this file at any future dates. Is that correct, ma'am?
Yes.
All right. All right. So at this probation arraignment, I've read the allegations that have been brought against you. You have a right to a hearing in this matter. You have the right to counsel, and you have the right to have counsel cross-examine or contest any charges brought against you by the people of the state of Michigan. We will set this for formal hearing to give an opportunity for your public defender's office and the probation department to discuss this case and then to come to whatever resolution or have a hearing. The probation violation hearing will be on
April 22nd at 1:30.
April 22nd at 1:30. All right, so Ms. Porter Miller, your hearing it'll be live in person on the 6th floor City Hall of Lansing. You'll be on April 22nd at 1:30, and you'll be represented by the public defender's office as previously indicated, and then we'll go from there on the hearing. All right, ma'am?
All right.
All right. Do you have any questions of me concerning the April 22nd at 1:30 date?
No.
All right. We'll see you on April 22nd at 1:30. Thank you for your appearance today. You should be all set.
All right, thank you.
On the Samsung, because we do have one arraignment with Mr. Magoon. Sir, what's your name? On the Samsung cell phone, what's your name?
Patricia Flanagan.
Patricia Flanagan. Are you here for your 2:30 with Michael Flanagan?
Yes, Michael's deceased, so.
Okay,
yeah.
Michael's deceased, and you're here for FR Lansing LLC, is that correct? That case 24040079?
Correct.
All right, stand by, you're in the right place, ma'am. We're finishing up a 1:30 docket, but you're in the right place for the 2:30 docket, all right, ma'am?
Thank you.
Thank you. All right, so Mr. Carries, I will go ahead and call Mr. Magoon. You didn't have the opportunity to speak with him, obviously, because he's not here. So I think you should be all finished today. We only had those two arraignments.
Thank you, Your Honor.
Thank you, Mr. Harris. All right, so we're on the record in docket 2400159. That is people of the state of Michigan versus Christopher Magoon. This is the time set for a probation violation arraignment. It was scheduled for 1:30. It is now 2:27. It would appear the defendant has failed to appear for the probation violation arraignment. I do not see Mr. Magoon in the Zoom courtroom. There's nobody by that name in the physical courtroom and nobody answered by that name in the hallway. So it appears that defendant has failed to appear for his probation violation arraignment. This is an assaultive crime, attempt assaultive crime. It was a no contest plea. I'll issue a bench warrant with a bond forfeiture for the fail to appear for a probation violation. And that's all for the record in 24-00159. On that, we're all set on that.
So they only do the, yeah, if they schedule, they do the schedule.
Thank you, Your Honor. Have a good.
You too. Thank you, Mr. Harris. Thank you, Mr. Lee. Ms. Reed, you're here for the Palace Law Firm on FR Lansing LLC.
Yes, good morning, or well, good afternoon.
Good afternoon. Let me bring that up and then I might be able to call that. FR Lansing. All right, and Ms. Pallets, I have Patricia Flanagan here, who is Michael Flanagan is the deceased. Is that correct?
I don't know if you're asking me or Mrs. Flanagan, but it's my understanding.
Yeah, that's my understanding. That's why we have Patricia Flanagan instead of Michael Flanagan. because, all right, and so we're on the record in docket 24040079. That is FR Lansing LLC versus Michael Flanagan. I still have parties appearances for the record. Ms. Reed.
Thank you, Your Honor. Sarah Reed on behalf of the plaintiff.
And Ms. Flanagan, you're Patricia Flanagan. You're here on behalf of Michael Flanagan, who is deceased. Is that correct?
That is correct.
All right, thank you. All right, this is time set for a motion, and I am in possession of the Flanagan motion. This is an order granting plaintiff's motion for reissuance of order of eviction. Ms. Reed, you may proceed. Did you want to meet with Ms. Patricia Flanagan or go forward with the motion? It's entirely up to you.
I think at this point, Your Honor, I can just go forward and then we'll just see where that leads.
All right, you may proceed.
All right, thank you, Your Honor. So, Your Honor, I'll be as brief as I can. This case was actually initiated almost a year ago, back in May of 2024. At that time, at some point in time, judgment was entered, and the writ was eventually issued and signed by this court. Subsequently, Ms. Flanagan filed for bankruptcy. That has obviously been discharged now. The home is obviously still sitting at Mill Pond. The current outstanding rental obligation with adding on April's today is approximately $6,600. Obviously, my client couldn't proceed in any way, shape, or form while the bankruptcy was pending. But since that has been discharged, my client did want to proceed at this point in time. We've got some questions about the ownership of the home. I don't know if an estate was open, but it was originally titled in Mr. Flanagan's name alone. So there's some other issues that I don't know if had been resolved by the bankruptcy court or not. But again, just to reiterate, my client just wants to proceed with the order of eviction at this point.
All right, Ms. Flanagan, do you have any response to the order of eviction concerning the home that was the subject of bankruptcy? So there was no movement on the home. And then I did read that it was discharged as a part of the bankruptcy proceeding. Do you have any statements to be made concerning the plaintiff's motion for reissuance of order of eviction?
Yes, sir. Thank you.
All right,
Sorry.
Go ahead, ma'am.
Okay. I have tried the law firm quite a few times in the last probably 30 days. I did talk to Sheila, the park manager here, and I've also talked to Tracy, the mortgage holder, or the representative. I've come into an inheritance. I've offered pallets, copies of those agreements to show that I am entitled to money that is coming. I made the offer 2 pallets in an email yesterday again, saying I would pay March and April's rent on the 3rd of this month. I'm also paying 2 months rent on the mortgage payment on the 3rd of this month. The attorney in the settlement case has said that the court has ordered the award check to be delivered to his office no later than Wednesday of this week. And he assumes that by the time they write that and we wait for any holds our banks put on it, that by the 15th of the month, I should be able to pay the $6,102, which included March's rent, and the $4,183 owed to the mortgage company. Then I also stated in the letter the mail I sent 2 pallets that if in fact this wasn't remedied by the 1st of May, that we would vacate the property. But when I talked to Sheila this morning and Jade, they agreed that we can stay if we pay the balances before May 1st.
Ms. Reed, did you have that information or was that given to you? I know you're appointed by the Hallett's Law Firm for the hearing today. Were you aware of that information provided to Ms. Flanagan or from the property manager as just indicated?
Your Honor, I wasn't. I did try to reach out to my client yesterday. I don't have any reason to believe that Ms. Flanagan would not be truthful about her conversation. The manager is Melissa. Sheila left quite a few years ago, but
Right.
I don't know if Your Honor wants to adjourn this maybe out. I think Ms. Flanagan said by the 15th, she expected to have all this resolved.
She did.
Yeah, I don't have a problem if we adjourn this out to a date past that to see, what transpires in the meantime.
Yeah, I think that's probably the more prudent thing to do at this point in time with new information after this case. This case is about a year old. And I do think that since coming out of the bankruptcy discharge, we've kind of got a different set of at least facts coming out of that. I will adjourn the order granting. I will adjourn the motion for reissuance of order of eviction. I will adjourn that at the party's request. And we'll adjourn to probably the end of April, I would think, which would get us past the April 15th date.
Sure.
We could go to after May 1st to make sure that everything's taken care of after May 1st, because I think there's actually a move out date of May 1st the property manager was talking about. I don't know if that's true or not, but it might behoove us to move it past May 1st.
Sure. I don't have any objection to that, Your Honor.
All right. So let's move it to past May 1st to May 5th at 10 o'clock. So we'll move to, we'll adjourn this matter to May 5th at 10 o'clock. Zoom is appropriate for this. So we can hold this by Zoom. And by that time, we'll have more information to go forward on the case. Anything else for the record in docket 2404079, Ms. Reed?
No, thank you very much, Your Honor. I appreciate your time.
Ms. Flanagan, do you have any questions of me concerning this matter? We've adjourned to May 5th at 10 o'clock.
No, sir. Thank you.
All right. Thank you. You're all set, ma'am. Thank you for your appearance. Thank you, Ms. Reed.
Okay. Thank you, Your Honor. Have a good day.
You too.
Thanks.
And then, Mr. Smith, you're here on Lansing Automakers.
Yes, Your Honor.
And we're awaiting Danielle Kennedy. Is that correct?
That is correct, Your Honor.
All right. So let's give Ms. Kennedy about 4 or 5 minutes, and then we'll check the hallway and the courtroom, and then I'll call the case.
Thank you, Judge. Your Honor.
Mr. Smith, did you want to go forward on Lansing Automakers?
Yes, Your Honor. I think we were scheduled at 2:30. Personal service to be reflected in the court file. It's now 2:53. Perhaps we can.
All right, let me call that case. We're on the record at 1200243 GC. It's Lansing Automakers versus Danielle Kennedy. Will the parties please introduce themselves for the record, Mr. Smith?
No, for Plant Blackfoot, Tim Smith, P48259. Good afternoon, Your Honor.
Good afternoon. I do not see Miss Kennedy in the Zoom courtroom. I see an iPhone 4. Would the person on the iPhone 4 please identify yourself?
Yes, this is Danielle Kennedy. I'm not sure how to do the camera.
All right, so Miss Kennedy, you are here. We're about to bench warrant you.
Yeah,
This
they
is a
put the
discovery
wrong
hearing.
Zoom ID on my paperwork and told me it was in front of Judge Buchanan, so I was also in that waiting room. So there's no need for that.
There's no need for what?
For the bench warrant or anything like that.
All right. Well, you're here now, and this is a discovery hearing, Mr. Smith. I'm going to indicate that you're here, and Miss Kennedy is also here.
Correct.
Mr. Smith, did you want to meet with Miss Kennedy for the discovery hearing? I can place you in a breakout room, and I can swear her in beforehand, but she doesn't have any video, so we can't see that, but I can swear her in orally in order for the discovery hearing to take place.
Whatever sworn in, we'll do the discovery exam after the swearing in.
But so there's no need for the swearing?
No, let's swear her in, then we can go to the breakout and I'll do it.
All right. And I do see, so Ms. Kennedy, I'm going to have you raise your hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of
Yes.
perjury?
Yes, sir.
All right, thank you. All right, so Mr. Smith, with that swear in, we'll start the discovery exam and I will place you, and you should get a prompt to go to room 1, and then I will get Miss Kennedy a prompt to go to room 1, and then we come back and put it on the record. All right, sir?
Thank you, Judge.
All right. So Mr. Smith, you'll get a prompt to go to room 1, and Miss Kennedy, you will also get a prompt to go to room 1. Mr. Garlinghouse, what case are you here on?
I'm here for Midland Funding versus Cohen,
All right,
filling in for Mary Jean Elliott's office.
all right. And so you're waiting Lawrence Cohn?
Yeah, waiting for.
Yeah, because it's set for 3 o'clock and I don't see. And then Mr. Meineke, you're here on TNT Financial, is that correct?
That's correct, Judge.
All right, and we are waiting on a Jarrell Clemens, is that correct?
Yes, Judge.
And ma'am, are you Shamira Houston? Yes. All right, all right. And so we're waiting on the motion to set aside judgment. We're waiting on the representative from Capital Alliance. Is that correct? Okay. All right. Once we have a pair, we'll call the case. Okay. We have everything but a pair. But once we have both litigants here, we'll call the case. This was scheduled for 3, and we'll give till 3:15 before I start calling defaults. All right.
Thank you.
Thank you. And if you need to go put money in,
I was just about to.
feel
ask if
free.
that's okay.
Feel free. Yes.
Thank
You're
you.
free to leave and come back.
It is, because the numbers don't work on the plans. So it's just like.
All right. This is, what was his initial? There's that. I never thought of.
Now we have Joseph Jamal for
Oh.
Capital Alliance.
All right,
As soon as she leaves.
that's all right.
That's the universal.
Yeah, that's we know where she is or where she's supposed to be. All right, Mr. Jamal, you're here for Capital Alliance, is that correct?
That's correct. Good afternoon.
All right, good afternoon. Miss Houston is here. She's just she left to go put parking meter money. I think we'll call your case as soon as she gets back. All right.
Okay, that'd be great.
All right.
And if there's,
Thanks.
I'm not sure if there's a way or not. I mean, I'd be more than willing to talk to her in a breakout room if that's possible.
Absolutely. Yep.
Okay.
I'll give that as an option, and if you want to talk before the motion, we can set that up.
Okay, fantastic. Thank you, Judge.
Thank you. All right, Mr. Smith, did you want me to bring back Miss Kennedy?
Yes, Your Honor, there are some documents responsive to the subpoena. We just need to get a control date for those documents.
All right, let me bring her back to the main session here. All right, so we are back on the record in docket 12-00243. And it's my understanding, Mr. Smith, you've had the opportunity to meet with Miss Kennedy, and there's some outstanding documents as part of the discovery. Is that correct, sir?
That's correct, Your Honor. Paragraph C of the subpoena indicated a number of documents that were to be produced today. We'd like to give the defendant 30 days to get us certain documents related to her employment situation. I'll get in writing to her to the address that I just confirmed, reminding her of what needs to be sent, where to send it. I think 30 days would be enough time, but if we keep a control date in place in case we don't receive those documents, that would be good. If I do receive the documents, we can contact the court and cancel the date.
All right, and that's your understanding, Ms. Kennedy. We're going to set for control date, and that'll give you some time to get the documents together to provide to Mr. Smith. Is that correct?
Yes, sir.
All right, so we'll set a control date for, and we're looking at about 30 days, Mr. Smith,
Yes, Your Honor.
in that vicinity.
May 5th at 10:30.
May 5th at 10:30.
That works. If we do receive the documents ahead of that date, we'll contact both the defendant and the clerk to take it off the docket. Okay.
All right, perfect. All right, so Ms. Kennedy, you've received the notice. You'll be sent notice, but you received orally the notice for May 5th at 10:30, and then Mr. Smith will let us know if we need that date or not. Okay, ma'am?
Okay.
All right. Anything else for the record in 1200243, Mr. Smith?
Nothing, Your Honor. Thank you.
All right, thank you. Ms. Kennedy, do you have any questions of me?
No, thank you.
All right, you're all set. We'll see you on May 5th at 10:30 unless we hear differently from the parties.
Thank you.
All right, Mr. Jamal, we can call that case. So we're on the record in docket 1402227 GC. That's Capital Alliance versus Shamira Houston. Will the parties please introduce themselves for the record? Mr. Jamal.
Yes, good afternoon. Joseph Jamal here on behalf of the plaintiff, P71254.
Thank you. And ma'am, you are Shamira Houston, is that correct?
Shamaria.
Shamaria?
I'm sorry.
That fine. So you are Shamaria Houston, is that correct?
Yes, Judge.
All right, this is the time set for a motion in the matter. I always give the parties an opportunity to speak to one another. So if Mr. Jamal he's amenable to speaking with you, we can place you on an iPad and give you some security if you'd like to talk with him to discuss some of the legal issues that led to this motion. Would you be amenable to that?
Yes.
All right. So follow my court officer, and we'll place her on an iPad. Miss Houston on iPad, and then Mr. Jamal, I will place you in room 1, and then I'll place the iPad in room 1, and then we'll come back and put it on the record after you've had a chance to discuss.
Fantastic. Thank you, Judge.
All right. So let's put you in room 1, and then you'll be joined by Miss Houston. And we'll call yours and Mr. Meineke's case in about 5 minutes.
Okay, that's
Yeah.
fine. It's it's always funny when they get stood up on their motion.
Yeah, I know.
Not to mention the fact that the civil department asked me special to like shove these in.
And
here
they're
today.
both pro per motions.
Of course.
Yeah, so both of them. I think this is an objection to installments by TNT because he wanted to make installment payments.
Gotcha. Yeah, this is mine's a tax garnishment.
Yes.
So yeah. That's all.
Yeah, we'll wait and see. I don't see the iPad yet. Here we are. All set.
You do this for the one picture.
Mr. Meineke, let's call your file next on docket 23033192. I almost don't know what to do with this file because I have a paper file, and but I do have it, and I did print off the order. So this is an objection to the order for installment payments. Mr. Meineke, your appearance for the record concerning this file.
Good afternoon, Your Honor. James Meineke appearing on behalf of the plaintiff T&T Financial, P40512.
All right, this is the time set for this was I think this is an objection to the order regarding installment of payments. And it was initially filed the objection was filed by T&T. This is the initial, the installment of payments was made by Mr. Clemens. It is now 3 o'clock. This was scheduled for 3 o'clock. It is now 3:21. It would appear that D1 is not present for the objection. And Mr. Meineke, how would you like to proceed?
Your Honor, I'd just like to simply state that this is this was a motion for installment payments by the co-signer Jarrell Clemens only. Logan Wynn did not file any objections. We do not have any wage garnishments against her. Mr. Clemens was seeking $20 biweekly to begin on May 22nd, 2022. We objected to that. Based on his failure to appear today, we'd ask you to deny his motion for installment payments.
All right. And I have a full amount of judgment at $13,982.95. That was on the last paperwork that he submitted. Does that match up with your paperwork, sir?
It does, Judge. I believe that's the amount from the wage garnishment we had filed with the court, directed to American Plumbing Contractors. Yeah, $13,982.95 is the original amount of the judgment.
All right. So what I'll do is I'm going to, for the fail to appear, I'm gonna enter the motion for installment payment is denied for reasons stated on the record. And so I'll deny any installment payments. He was asking $20 every 2 weeks for May 22nd. That's denied. And then, so you don't have to follow up with an order. This should be sufficient for our purposes.
Right. Thank you, Your Honor.
And then we will sign it and scan it. Order. Signed and scanned. Denying installment payments. All right, anything else for the record in 2303-192, Mr. Meineke?
Nothing further today, Judge.
All right, you're all set. Thank you for your appearance today.
Thank you.
And I've got the order and signed order, so Megan can sign and scan that.
It signed and scanned.
Was it what's that?
I think it just goes in the file, no?
No, I think it's got to be signed. Well, I printed it off, so maybe, and that's the one that what they said it was on base. Does that have the blue note inside of it?
Yeah.
So I don't know. I don't know the answer to your question.
Yeah,
I don't know if we put it in the file, if that's good enough, or because it was filed on base, I signed and scanned it. So make a phone call or an email and let them tell you what to do with it. Because we can scan it easily, or we can stick it in the file.
Let's see if they even have a case open
All
for
right.
this one on base, and then if they do, I'll just import it.
Oh.
But from my experience, I think I just make copies.
Uh,
Not copies, I just.
That would
put it
make
in the
sense.
file. Yeah, because
If they hadn't given us an order to go, oh, here's the note.
Yeah.
That's the note from Austin.
yeah, it's not even popping up on here.
All
Your
right.
link.
All right, so we're on the record. Miss Houston, you can come up here. We're on the record in docket 1402227. That's Capital Alliance versus Shamaria Houston. And Mr. Jamal, did you have the opportunity to meet with Miss Houston in a breakout room?
Yes, I did.
All right. What, if anything, came from that meeting?
Yeah, so the parties did agree to terms of settlement on the matter. We're gonna need 60 days to get those terms completed. Defendant has also indicated that there should not be any sort of tax withholding as it relates to our firm. And that's why we're here today, is the state tax garnishment filed by plaintiff in the matter. So I believe those objections can be considered and held invalid. However, as I indicated, as long as the settlement payment is made within 60 days, we will be satisfying this judgment.
All right, so are we looking for a control date out 60 days just in case? And then you can let us know if we need it or not?
Yeah, I think that'd be a good idea. And maybe if we could make that sometime on or after June 15th, that'll give us time to get the payment and file the
Right.
satisfaction.
Yeah, that'll work some time in and you can negotiate and you can make payment on that. And then if we need the control date, fines. If we don't, so we'll adjourn the motion date to the control date and then go from there. All right. Does that work, Mr. Jamal?
Yes,
All
it
right.
does.
Oh, all right. So control date is set for, we'll set it for 60 days out.
June 17th at 2:30.
So we'll set it for June 17th at 2:30. And ma'am, you'll get notification from my court officer for the June 17th at 2:30 date. And Mr. Jamal, you have that date of June 17th at 2:30. And then I'll wait to hear from the litigants if that date is necessary.
Fantastic. Thank you, Judge.
All right. Anything else for the record in 1402227, Mr. Jamal?
The only thing I would mention is we did come to an agreement as far as payment. Ms. Houston, you'll just want to make that payment directly to my office, which is Stenger and Stenger, and reference the case number, the plaintiff when you do that.
Right. So yeah, that should be on the paperwork, and then make sure you make reference to 1402227. Is that correct, Mr. Jamal?
That, or at the very bottom, you'll see a internal file number, which is 14-05753. If you put that on any sort of payment you made, that'll be the quickest reference to make.
Okay. Do you want to write that on there?
Yes.
Yeah.
I was
So
gonna say, I don't
just
see
in
that in
case,
any of
so.
ours.
Yeah, it is. Once again,
Okay, so go ahead.
I'm ready.
Go ahead.
14-05753.
That'll get the payment to the right place. All right. All right. Do you have any other questions of me, Ms. Houston?
Yes, the only question I have is, will I get, once everything is paid, will I have a finalized receipt back to me saying that it's all set?
You'll get either you'll get something from the court, or Mr. Jamal will send you something indicating that the complaint has been satisfied. Is that correct, Mr. Jamal?
That's correct. Upon payment and confirmation, we'll file a satisfaction of judgment, which is going to be filed with the court, and you'll get a copy of that as well.
Okay,
All right.
thank you.
That's a good question, Ms. Houston. Any other questions?
No, Judge.
All right.
Thank you.
All right. You should be all set, Mr. Jamal. Thank you for your appearance. Thank you, Ms. Houston.
Yes, thank you all.
All right.
Thank you so much. I appreciate it. Have a good one.
You too.
Thank you.
Not too bad for being loaded up. The civil department was